bonds must be on file at the Secretary of State's office. And the way that you get these bonds is you communicate with the Secretary of State's office, Division of License and Services. You send them the name of the corporate entity and a specific request for proof of insurance or bond. It must be on file. They'll give it to you. It's public information. Now you know who to file your claim with. This is law outside of the venue. Why? It's common law. Because you have a right to make a claim. Especially because they have made a guarantee publicly and it's contractual. So now when you make the claim on the bond, you're making the claim to the people who's putting up the bond. What they want to do is investigate the claim. Once they see the claim is a claim they can't win, what they want to do is negotiate to try to give you a portion of the bond as opposed to the whole of the bond. That's up to you. Understand, the servicing company has a $100,000 bond. So when you catch the process server engaging in unauthorized acts, fraud, violations of the New York State process services or laws or rules, because there are specific regulations governing these things. And if you study them, you polka dot them with bad acts. You get an affidavit of service and there's no index number on the affidavit is void as a matter of law. Structural defect. You look at the notarization, you look at the jurat. The jurat, what the jurats usually say, buttercup, sworn before me, pop, pop, pop. That is improper. That is unlawful. And it is not in accordance with the laws for the state of New York. Mind you, I'm beating them up with their own shit. You look at the laws for a notary. Notaries have notary laws and rules. And they can't get away with ignorance because they must be educated in the courses before they're authorized. So this is the fail-safe. Now when you catch the process server saying, I personally served Jonathan Winters by a person of suitable age and discretion at the location, and the person was John Doe, and understand this.
John Doe.
This is what they do.
But you get it with the John Doe.
But wait a minute. I'm glad you put that in there. See, because if you know what they're obligated to do, soon as they do something wrong, you got them. Remember the importance of this document.
Right.
The court's jurisdiction is based on this document. I don't give a fuck what the claims or the facts are. If this document is void, they must dismiss. They have no subject matter jurisdiction, no personal jurisdiction. They hit. That's the importance of the affidavit of service. And mind you, it's not being filed by the attorney. It's not being filed by the people who filed the action, Servicing Corporation. Right. It's not being filed by the trust company who's claiming to be holding the promissory note on behalf of this mysterious trust.
There is no promissory note there.
It's none of these guys. It's some guy who was sitting at his desk and said, yeah, I need you to serve these documents. His boss came and said that to him. His boss just got a call or email and said, yes, I need your process service to serve these documents. Mm-hmm. They're totally not related.
Right.
But these people who they're giving these documents to are actually dictating your position in court. Because when they throw those documents on the side of the house and say they gave them to you personally, or when they give it to John Doe XYZ, and then the military affidavit is fucked up. Oh, I spoke to John Doe neighbor next door, and they informed me that Quincy Jones is not in the military or dependent upon anyone. That little phrase right there, that one little military affidavit can get the whole case thrown out because it's federal.
Right.
That is a service member's notice. If you in the armed forces, reserves, anything like that, you might be deployed across seas. So when they come and put a service on your door, you're not there, you have no notice of it. I'm all fighting for the country, and I come back and my house is gone. So Congress initiated these protections, and they go across the board to all the states. All the affidavits of service must have a military affidavit attached. Now, when you get familiar with this, you'll see that the people who do it correctly, they do a national database search to see if you're in any of the armed forces. And there is a readout that's given to them by the federal government. Mm-hmm. But you just got a complaint served on you, and none of that shit was in it.
Right.
No, none of those documents was in it. But the service provider has sworn under oath that he has complied with the rules and regulations of the state of New York in regards to service of documents. He's stated under oath that he's complied with the CPLR, the practices of this is court. He's bonded to this, and he's under oath. So soon as you catch one thing fraudulent in that document, you just earned $110,000. You just got his bond and the company he worked for, and you ain't even filed a suit yet.
Right.
All you need to do is send them a notice of claim with the documentary evidence to support your claim. So when they investigate it, they say, oh shit, he dies. They probably gonna want to give you half and half, $55,000, but you ain't even went in court yet. Take it, it was free. Why? Because when you bang them, that's an automatic admission that the documents that the plaintiff is relying on
were in error
and cannot be used for a judgment. Banging him, you just beat the case. You understand? And if you understand this, these documents were then submitted by an attorney into the record. Well, there is a federal statute and a state statute on bad faith filings, false statements and filings. You got professional misconduct, malpractice. You understand? This is where you bang them. See, they so busy trying to whoop you with it, but if you just do your homework, you'll understand. Everything that's out there is a pale reflection of jurisprudence. They can't establish anything else. Because in order to keep the masses asleep, you got to keep them comfortable that they have some sense of remedy. And then you have their oaths that they're bound by. So you have that little ground where they teeter-totter between trying to get their position and do what they want to do and having to keep a good look, keep a good face on it.
What they do, even in those venues, with those people calling themselves judges, in order for them to hear a case, they must have a $100,000 bond
as well
for that case. If they don't have that bond, dismiss. Then you can bang them for that violation.
Well, let me show you this, right? Within the state of New York, right, you have different investigative administrative bodies.
True.
One of the chief ones that you need to get familiar with is called the DOI. It's called
Department of Investigation.
Okay. Now, they are the guys who investigate internal affairs. They investigate the guys who investigate the police. Now, with them, they have statutes that's going back all the way to Koch that haven't been changed. When you look into what they are for, what they do, and how to provide evidence to them, you'll understand that if you file a claim with them, it will freeze any civil action out there. Anytime you file a claim with them, it freezes any civil action because they are an organ of the state. And the state courts are connected. They cannot be conducting an investigation at the same time that a trial is being heard. They must choose. Once you file a claim with the Department of Investigation, they can't choose. They're obligated to investigate, which is like a domino effect, means they must notify the court of the existence of the investigation. Now the magistrate, knowing of the investigation, has to choose. And to stay all proceedings until the investigation is over. So where the magistrate don't want to hear your evidence and claims, you can circumvent her through another administrative agency that's obligated to investigate every allegation and give a report on its findings. The one thing you want to file a claim with them about is a little known law called Public Law 19500. And if you look into law, they always tell you about check the local laws. The local laws have superseded standing than the statutes. The local laws are more powerful than the statutes and the codes within their jurisdiction. That's law, that's fact. So now what you're using is a local law. Public Law 19500 is for official misconduct. Now when you look that up, it's a beautiful thing because most of the time they're expecting you to come at them claiming that they did something. And that's usually how you get them. But when you look into this code, this particular statute, this local rule, it says, anytime an administrative agent does an act which exceeds their limited administrative authority, they are hit, and the state don't cover them. But it also says, anytime they fail to perform a duty that is obligated upon them by the nature of their office. Wait a minute. Remember sua sponte?
Yeah.
Remember that obligation of the court to dismiss upon a recognition of fraud, error, malfeasance?
Even telling them to withdraw from the case.
Right, even to recuse yourself. They're
yourself.
obligated. This is where you file the complaint with, right? And when they investigate it, they have to bring out the findings. So when you file your complaint, make sure you file your complaint like a legal argument. You're filing the facts, the documentary evidence and support. You're going to give a brief and summary, and you're also going to give what is called a memorandum of law. See, so I'm not making unsupported allegations because the documentary evidence shows that there are facts, and the memorandum of law gives you guidance on the relevance of these facts. Now, they got to go to the legal department, and the legal department hit because I'm hitting
their
you.
hands up.
They can't do nothing with it. So what is the result? Your claim was valid. Guess what happened? Now you file a claim with the Court of Claims because now you're suing the state. There's no way they can move forward with an action when the Department of Investigation have found that you were correct and they must dismiss the case. And now after you took that bond money, you at the state, but you also got that agent. But guess what? He's not protected by the state because what he did was not in the performance of his duties. When he commits an act that's not in the performance of his duty, the liability is personal. Now you lien his house and his bank accounts.
Because they all are supposed to be under the Foreign Agent Registration Act registered. And if they're not registered, they are not even lawful. Rather, not even lawful, they're not even able to operate as a foreign agent on
All
the
you
land.
have to do to kill them with that is file a notice of removal and remove it to federal court. I'll tell you, you can kill it. You can be up front on the man with a pistol, bang, 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 bang. But if you got blanks in the gun, it don't make no difference. They are not going to entertain that federal argument in these state courts. You're absolutely correct. I'm not contradicting you. But I'm just saying for the record that what I'm specifically talking about is dealing with these crafty devils within these state venues. You understand? Because for the most part, this is where 90% of the claims that we get confronted with emanate from. We don't usually get confronted with federal claims.
Right.
We get confronted with state claims.
Civil and state claims.
Right. If you are of the mindset where I only want to deal with federal statutes and codes, fine. That's more than sufficient. But no, you can't do that in this palm. Shift it. Then run them up. But if you're not to that point, or if the case is initiated, or they filed the shit and didn't serve you, and by the time you found out, you're in default. You can't just remove a case that's in default status to federal court. You're gonna have to get that case back on the calendar within that venue, then file to move it. Because you're in default and they pass the judgment, it's dead. You can't move a dead issue to another venue. You have to resuscitate it, which means you gotta go back in that venue anyway, unless you file suit, which is another horse. If you file suit, you can file suit all you want, but to challenge the judgment, if you file suit in federal court, the federal court is going to demand proof that you exhausted the state remedies before they entertain any remedy for you. And they're going to dismiss your claim for failure to state a claim for which relief can be granted. I walk this dog. I'm telling you how to go about this. Like, I kill them in their own ponds. I don't got this. We're in freshwater fishing. We're in saltwater fishing.
Right.
That's how it's going down. So I'm never going to say, oh, mentioning federal statutes and codes are not relevant. Bullshit. Because they are. But what I'm telling you is a way to deal with the circumstances that really, it doesn't matter what the details are. Because we're not watching details. We're not watching subject matter. We're watching structural defects. You understand? That automatically deny the court of jurisdiction. As Moors, we are taught that we know they have no jurisdiction challenging. But as a practical, active Moor, believe me, I've done that shit for years. And I always end up fighting in another court because they're not going to acknowledge the stance because they can't. They can't even hear it. They can't even write a response to the shit. They're administrative agents. They're barred. Aces versus US. You must always remember that. Because you'll be in there spitting lava and hoo-ha and stack of documents and you be right as a motherfucker and wrong as hell. Because you bring in the right argument to the wrong venue.
Right.
And that's what's killing you. It's not that you're wrong. And I know a lot of Moors who get disillusioned. Man, this shit ain't working. And no, brother. You're not taking a step back and reassessing what's going on here. Stop going in these venues and acting like everybody is your enemy. Your mother ain't teach you that you get more with honey than with vinegar. You come in there hostile, aggressive. These is public service. They work for you. And they're obligated to give you information if you request it. And when you need information, you get it from them. I rape them by making them tell me. All the time. You understand? I don't got no beef with the magistrate. Why? Because she ain't got a motherfucking thing to say unless this motherfucker can prove he got a reason to be here. Part of my language. You ain't got nothing to do with it. You're a payroll. The real crook in the court is the clerk.
Right.
You understand? So that's the one you notice of the defects because that's the one who's obligated to reject them. That's the docket. She's the doc. When you receive these documents in doc, you're the one who's analyzing the manifest. You. And when you greenlight them and they're not in proper order, you're in violation of your duty. Because you clerks got a rule book too. But see, you're not paying, a lot of times we just caught on, I know law, I know, fuck your statutes. No, bro. Check this out, man. This is about knowledge and wisdom. In your wisdom, utilize what's available to you that is a sure remedy. Move off of your stubbornness because you have a particular way you want to do this. What's practical is what's beneficial to you. You want to live your life fighting and proving to something they already know. They know who you are. They know they operate in an equitable jurisdiction. You watch their face when you go up in there talking equity. When the brother asked me today, who are you? And I told him, I'm the secured party creditor in possession. You put out a universal notice to all interested parties. I don't have to be personally identified within the complaint. That's a public notice to all interested parties. Do you have a superior claim? Are you claiming ownership? Most definitely. Fee simple, absolute. But I also have an equitable interest. I have a possessory interest. I have contractual interest. What's your position? Oh, well, we bought rights. Well, listen, you bought rights. A man can transfer no more than he possesses. Did someone transfer to you actual physical possession? No. Did the person you contracted with, were they in actual physical possession and control? Constructive or otherwise? No. So what you have is a four-corner document, which is a contractual agreement in equity with parties other than us. That's not enforceable here. Why? Because I have a right of possession. Possession is 9/10 of the law. And the UCC, when you file that UCC and you're an actual possessor, understand what's your position. There is an unsecured party creditor and a secured party creditor. An unsecured party creditor has filed no financing statement. So understand what's going on. They're claiming they're the owner or they have an equitable interest, but it's not protected. It's not protected because it's not secure. And that no state can violate because they're all party to the UCC. Now review Article 9, rights and duties of a secure party and creditor in possession. It's going to tell you what your obligations are. You understand? This ain't got nothing to do with no statutes and codes. Every one of these courts is equity courts. You go in there talking the statutes and codes, they deal with you that. Go in there talking creditor, debtor, and equity, they got to deal with it. Every notice you get in the court says, we are debt collectors, attempting to collect the debt. That's the primary statement. You're a third-party interloper. You must prove standing to bring this claim forward. This is why you attack them at the door.
They cannot be debt collectors.
That's what your claim is. I'm not justifying you. I'm going to imprison you with it. You understand? Because as you make the claim that you're a debt collector, you make the admission that you're not the owner or directly interested party. Right. Now, it's sugar and salt at the same time. That's the position you took. But I'm attacking that because where's the evidence which shows that you are actually authorized to collect this debt on behalf of another? That must be in writing. That must be in the court's record. There must be an affidavit of service showing that these documents were delivered to me.
Right.
There must be proof of receipt. That certificate of mailing, that green and white slip, is not proof. It's the green card where it says service by certified mail, return receipt requested. Why are you allowing them to move forward with just the proof of mailing when the statute, the corner low says the return receipt is the proof?
Because it has to have a signature.
So how do you get them? You go to the post office. They got the certificate of mailing. They're gonna Xerox that, put that on and file it. Fine, thank you. Go get the tracking number. Go to the post office. Tell them to track it. When it was sent out, when it was delivered, was it returned? They're going to give you a printout. You take that and you make that part of your evidence, your documentary evidence that the service was incomplete and not consistent with the statements that were made in the affidavit of service. Now you move to dismiss on fraud, misrepresentation of material issue of fact. You understand? When I tell you about them bonds, 110,000 every time you catch them lying. We're not even talking about the plaintiff, the bank, nobody else. We're talking about the faggot who said, yeah, I served them in compliance with law. Well, the law said, CPLR 308 said personal delivery, in-hand delivery. Did you attempt to do that? If you didn't do it, the law says you must provide an affidavit of due diligence showing what efforts were made to effect that. And when you look into that, you can't just move on to the next level. You got to try to attempt to locate them at their job, try to call somebody, Google them, all of these things. But you have to object and put these things on the record. You have to challenge it because they run in the machine, in and out, in and out. Oh, these niggas don't know nothing, bust their head. These niggas don't know nothing, bust their head. When you walk up in there, your documents done came before you, and your shit is right, they can't deal with you like that. You got to do your homework before you get there. A lot of times, I don't give a damn what they claiming. Man, I don't even care. Why? You got too many defects. The affidavit is no good. Why? It's not about competent party. You want to know the law on that? Trinzi versus Pagliaro. Trinzi versus Pagliaro all day long. An attorney's affirmation is informing, but it does not amount to evidence before the court. Evidence must come from the injured party, the facts, and otherwise. The attorney has no knowledge of the facts. So look at his documents. He told you that. He said, upon information and belief, objection. Have you stated based upon what information and what belief? Look at the statutes. This is the shit you using. Look at the case law. This is the shit you using. I don't gotta talk. Your shit is garbage. I know yours better than you. You're too comfortable with my people being slow. So now you become comfortable and just running this garbage through the course. You know, the clerk ain't gonna stop it. The magistrate ain't really gonna fight it. When the brother come up in here, he really ain't gonna know. If we give him an attorney, he fucked anyway. You understand? If he buys his own attorney, he fucked anyway. So it's you, the knowledgeable man who fights his own matters, who is the threat. But you're not a threat if you don't Sun Tzu. And what I mean by that is the art of war. If you do not master your enemy's tactics and ways, you will forever be surprised by them. But when you do, he can no longer use them on him. They become a liability to him. Because he has to change up, and he can't. Remember, your grandfather taught him. And this is a lot of things. I get upset when we taught them equity. We taught them commerce. How are you running from the fact that they're dealing in an equitable jurisdiction as a moor? You're supposed to be a master navigator. We control the spice routes, the silk routes, the gold. We taught y'all commercialism. We tax y'all. How is it that all of a sudden this is taboo? Oh no, I just gotta be. No. Drew Ali said, you have to finance this movement. Where's it coming from? Rocks and stones? What are you teaching your children? To be righteous, but to suffer? You're supposed to be teaching them business principles, economics, finance, so they can compete and rule. They're only ruling because our children are not being taught the fundamental principles. And why? Because we won't study it. I promise you, this is our shit. There's nothing that they created. But if you refuse to master your grandfather's work and allow them to run amok with it, you deserve the sufferation. You need to know. Hit his ass with a W-9. Not because you give a damn about the taxability, but because you know he obligated.
Mm-hmm.
Hit him with it. You want to do finance, so me, we're going to report it.
Because now, the issue is, when they get you in that venue, if you don't tell them about the W-9 and what is it, the 4940 and all of these documents, they're running from the tax that they're supposed to pay.
Facts.
And they're transferring the tax onto you to make you the liability with tax fraud. They put the tax fraud on you. They are the ones committing the tax fraud. So that's why these documents are necessary to even, when they even begin. I demand you produce your W-9, your 4940, the 39, I can't remember the other one, it's another one, but these documents are congruent with you not having to even argue your matter. Because if they don't have them, dismiss. It has to be dismissed. Then you file a claim against them for tax fraud.
And you notice the SEC, it's a securities fraud. Straight up and down, it's a securities fraud. Now, when you come at them from this perspective, very seldom will you find yourself on the defensive. I can guarantee, if you read, what is it, UCC Article 9, 602 and 607. Bro, if you got a UCC 1 financing statement on a property and you're in actual possession, you notice all interested parties of your intent to strictly foreclose if they fail to satisfy the debt. Under Article 9, they got 20 days. If they do not respond or satisfy within 20 days, you can sell the property, transfer the property, claim the property in satisfaction. This is under UCC. I don't give a fuck about no foreclosure in the court. I'm telling you, that is the superior equitable standard across all the states. UCC, as soon as you walk in it. What jurisdiction are you claiming? Is this an equitable venue? Is this an equity court? Do you acknowledge the UCC? Don't talk nothing else to them. It's it. UCC, Article 9. Who are you? Secure party creditor. Well, under the UCC, the only person who can be a debtor is an unsecured party. You see this financing statement filed with the state, the feds. I'm in actual possession. Heck of the keys. Tell me, show the keys. That right there constitutes perfection. Possession and filing constitutes perfection of the security interest. Now here this sucker is talking about he got a mortgage and he foreclosed it. I got a case where a nigga took a house from the bank after the foreclosure and the judge said, well, you failed to protect your security interests. These guys filed the UCC 1 on the leases and rents. So any rent or lease that can come from the property is secure. They're in possession. You have a lien. You have an equitable right, but you can't enforce it. Yeah. Why? Because these guys aren't party to the contract. Period. Now, when you look at a foreclosure sale, understand their terms and conditions of sale. Because the court knows they don't have no jurisdiction. So even though they issued an order of reference, they issued a judgment of foreclosure sale, the data sale, everything. When they go in to sign that shit, and I'm gonna bring it next time, I'll come a copy of it, right? You see, terms of sale. One of the terms of sale, and this is contractual, they agreed to this as part of their claim to have an interest in this property. They can't get around this. That their rights are subject, not superior. They are subject to the rights of any parties in possession, any lieners of record, not extinguished in this foreclosure action. You can, did you extinguish my rights there? Then they still exist. And this is where the court, this is why I tell you, they know what they're doing. Because after all the hoopla, they tell this motherfucker when you go to buy, look, you buy, okay, terms and conditions of sale. You gotta send a 90-day notice on tenants, and that's coming from the Protecting Tenants of Foreclosure Act. That's a federal act. They don't do it. They go right to the foreclosure sale, come down in the house, kick the door open, run it, or come down, put anybody out. That's automatic lawsuit. So look it up. Who you bought it? You bought it? Go pull up the terms of sale, go file order to show cause right against these dudes for fraud and violation of the conditions of sale. When they get in there, they hit. Did you comply with RPAPL 1303 and 1305, Real Property and Procedures Law, which says you must give 90-day notice to tenants, and if they have contracts, lease agreements, you must honor them for the full term of the lease. It's in the paperwork. You sent it, but did you do it? No, why? Because I had to go file an illegal eviction action. The lower court denied me. Fuck the lower court. The higher court is where you sign that contract with the terms and conditions of sale. I'm going right there and notify the court that you lied. The lower court got nothing to do with that. The higher court must acknowledge it because it's in writing and it came out of their court. What did they just do? They just voided their rights in the property. Period. And who they gonna sell it to now? Who else got a right to foreclose? What other foreclosures out there? You voided his rights. You the last man standing. Fuck a quiet title action. You file an action to clear title. Whole different proceeding. Quiet title action is an equitable argument. Clear title is common law and jurisprudence. I'm claiming all claims, even the state. I don't want no lot, no block number, nothing. All that's abstract. Longitude, latitude, turf, terrain. You challenge the state on that. They got no claim, they never made one. They claim lot and block numbers, corporate abstracts. This how you deal with them. Go up in their ass. Don't put no address, nothing. The address belongs to the state. Strip the number off it. Put their domain on it.
The address is the military.
Notify the post office, don't send no mail to this location with that corporate address on it. Only mail comes here is addressed and you get your own route number.
Right.
Period. Now, you're talking about, oh, it's in the territorial jurisdiction of the state. No, it's not. No, it's not. Department of Finance has no claim. Why? Because there ain't no lot and block number. That's on your tax map. I ain't on your tax map. Your tax map ain't got no coordinates. You want to fight? Let's go. What's your claim? Oh, lot and block, da-da. Longitude, latitude. We going to federal court. Guess what? There is no debate. You claiming one thing, I'm claiming another. You deal with your abstract shit, I'm going to deal with reality. I got the soil. You keep your abstract. You can't win because you can't. You're a corporate entity. You can't attach to land. It's a violation of law of physics. It's a violation of business corporation law. I tell you what, the corporation takes on the nationality of the owner. Where the fuck your grandmother from? Fuck you claiming land here. That's how you deal with them, but you do it articulately. You do it civilly. You do it academically. But that's the posture. That's the emotional and psychological posture. You got no rights here. And I'm not asking you, and I'm not depending on anything other than my knowledge. That's it. I'm not even dependent on my nationality or my bloodline. Because that's there, irrefutable. But what does that demand? That demands that I be who I am, not who you want me to be. That means I do what's right, wisely, not what I feel because I'm stubborn. That ain't my ancestors. We wise. Can't conquer your enemy with just brute strength, tactic, strategy. You understand? This is a war that's active on different levels. So I promise you, I'm with you. I go on federal court, federal arguments, statutes, all that. But most of the time, I'm helping people in civil court, in Supreme Court. You understand? Even criminal court. I treat criminal court like a civil court. Because they are.
Yeah.
Pull up another case so you bust him with. You want to kill him real quick? Go downstairs and tell him you want to file anything. Anything. Pay him and get a receipt. Kings County Clerk Office, paid. Then you go pull up the case called Clearfield Trust versus U.S. Clearfield Trust versus U.S.
Territorial 192.
Oh, Clearfield Trust versus U.S. specifically states that any time a so-called government body accepts private commercial paper, they are reduced to the mere status of a corporation.
That's it.
So give me a receipt for accepting this private commercial paper, these Federal Reserve notes. And this is my documentary evidence of the fact that you're operating in equity and that you accept private commercial paper. Now, here's the case law to support my claim that you have no jurisdiction to make any judgment in law because your status is that of a mere corporation. And by the way, the Pope fired all of you motherfuckers.
Yep.
2014.
You get the letter from the Pope, attach that. See, like, it's,
And
you got a
remember-
Rubik's Cube.
Remember, it's two letters from the Pope. You have the June 10th, 2014 letter as well. Then he did another one July 4th.
That's the reaffirmation.
Right, and each letter has a different nom de guerre. One says Negro, the June 10th says Negro, and the July 4th says African American. But you all know that those are the code words for Moors.
They're synonymous terms.
Okay,
They're
so
misnomers.
that right there in itself is the butter of all things.
So, you know,
So-
you can get them in many different ways. High, low, but the thing is, diligent study and what they're doing.
Right.
This is how I learned to beat them. I learned to beat them fighting for my life.
Well,
Out
this
there
is
in
a
the
life in that
streets,
thing.
you know, but you know, you pick up transferable skills. If you learn how to do plumbing in America, you can do it in China, Japan, Russia. It's a skill that transfers with you. I began studying law before I was conscious of my knowledge as a Moor, of being a Moor. I didn't even know what a Moor was when I had to fight for my life with these cats. So I learned from day one to fight with what was available. Later on in life, I was awoken to other things. And so now what you have is a blending. See, like, I don't mind fighting them in administrative capacity because I whooped them like that. Listen, I fought against the Feds, DA, Secret Service, same time. Tried to give me 30 to life. Then they begged me to take 36 months. You understand? This is before I was knowledgeable as a Moor. This is just about study, man. This is about diligence. You know what I mean? If you study these things as if your family's future depend on it, as if your people depend on your ability to decipher these things and master them. If you study them like that, you will get out of it these things. But if you're just a casual peruser, you understand? You can't expect to be fully equipped for a war with these cats when, first of all, they come in numbers, they practice, you understand? And for the most part, a lot of times we fighting by ourselves with limited resources. But it's okay to be by yourself if you equipped. It's okay if you have no resources. If you got the primary resource, a swift mind, you know what I mean, with knowledge of the subject matter and the will to see it through. See, these is the basics, man. I see so many different people take so many different approaches to dealing with the circumstance that we're in. But the one I always knew is the same one I stick with to this day. Read. Reading is fundamental. What the prophets say? Study. It's the same thing, man, because knowledge is a derivative of information, man. If you do not have information, you would not be able to make the conversion. You can't separate the wheat from the chaff if you don't know what the facts and the fuckery are. The facts is the wheat, the chaff is the fuckery. You have to study, period, like voluminously. Especially those things that affect you directly. When I started studying, shit, I was fighting attempt murder, gun charge, so that's what I studied. I learned how to shepherdize cases. I learned how to, follow a chain of evidence. You understand? And this is what we talk about with more. This is a chain of title. Same thing as chain of evidence. Catch a drug case. You follow the chain. Catch a gun case. Everybody better sign off, or the evidence is inadmissible because it's contaminated. This knowledge is transferable, so it transferred with me. Now, here we go. These cats is phony. They've been faking the whole time. And I've been suing you for 30 years. Now you got the double-edged sword. Because we all know they can't do nothing over here with this jurisprudence. They don't have the standard, and even if they stood up, they're only gonna be 2 foot tall and get their head chopped off. They know that, we know that. This is why when you go in there with that, they do everything in the world to avoid that. When they see my attribute, they already know it. Oh, he's a Moor, you know what, the debate. So they brace. He's gonna come in here, I'm a Moor, I'm a this, that, and the other. And when they don't get that, I swear, it's like so much of a sucker punch. They be like, who does that think he a lawyer? They forget all about that shit. Like, who told you that? See, this is the ultimate. See, because you're not even prepared for this fight. The last thing you expected me to do was run up in your house and throw all your papers in the air. And say, look, it's garbage. You expected me to stand over here and say, I'm superior, you're nobody. And then you have all your peoples and your guns and the system and all that. It's just hush, shut me down, punch me down, push me out, Marshall gonna kick me out, whatever, whatever. You don't go like that. I attacked what you filed. I didn't even file an answer. I never file answers. You file an answer, submit to the jurisdiction of the court. I file affidavits containing facts and challenges to jurisdiction. See, an affidavit must be rebutted. The only thing I respond to in the case is I challenge the affidavit of service and the affirmation of the attorney if it's not supported by an affidavit from the plaintiff. Those are jurisdictional challenges. It's just no different than if I walked in and said, what jurisdiction do you have? But I'm not saying it to him. I'm telling him that this dude right here had the burden of satisfying those things, and he did it. And he can't say shit. He got to say something. Mind your position, payroll, you must remain neutral. Are we showing bias? Are you practicing law from the bench on behalf of the plaintiff? Oh, watch yourself here. I filed these affidavits. The affidavit not rebutted stands as fact. Those facts for the case. Based on the fact that he failed to rebut the affidavit, I moved to dismiss. See, you got to deal with this. I don't give a fuck what his claims was. I didn't answer it. I said his notarizations was garbage. Yes, I challenged that. These is defects they can't move past. You can't even begin to talk subject matter once these jurisdictional challenges are before the court. And I do it right for you. CPLR 3211, subsection 8. Demand for dismissal, lack of jurisdiction. I told you what I came for. And since you act like you only speak codes, then get your code. I'm not obligated to the shit, but you are. Excuse me, not even you. He is, and you are obligated to scream whether or not he did it or not. So I'm telling you why I'm here, to clarify some things. This is a special appearance, not a general appearance. I'm a third party, interested third party, secure party creditor. You understand? I'm here to challenge the plaintiff's standing. What standing do I have? This UCC right here file. I don't need no lease. That's for a tenant. Tenants one holds property for another. I hold my shit for me. So move that. Secure party creditor. Do you know UCC Article 9? You know what a secure party creditor? I asked the magistrate that, to put you in that position. Don't play with me. Okay, so now, who has a superior claim? Do you need case law? What is he claiming? He's claiming to be of counsel to a law firm, to a servicing corporation, to a bank who claims to be a trust. Where is the evidence of the trust? Where is the evidence of the promissory note? Where is the evidence that the trust authorized the bank to initiate this action? Where is the evidence that the bank authorized this law firm? I don't see no evidence of hire. All I see is a claim from the law firm saying they hired me. Where's the proof? Now, the law firm, they didn't even show up. This guy said his name is Dave Watkins, and he said he's of counsel, but he hasn't submitted an of counsel agreement. What do you mean? This right here, New York State of counsel agreement. Have you ever seen one? Is there one in the court? He has no standing. Period. Move to strike anything he said. These documents were submitted by him. Move to strike and dismiss. Wow. The court has no jurisdiction. Now I'm talking to you. Prove it if you want to, but it's on him to do. See, when you bust them like that, and I don't care what you want to talk about. I'm not here to allow you. I'm here to deny you. I did my homework before I got here. My homework you sent to me. I don't give a damn what you're saying. I'm just looking for flaws. Structural defects, jurisdictional defects, facial insufficiencies. Oh, I memorize them. I can pick them up and see them on. Look at this jurat. Sworn before me. Oh, what's wrong with the jurat? Oh, I did it with specificity. It fails to state what form of evidence was used to verify that the affiant was actually the signatory. Oh, that's a law. You want to look it up? There's New York State notary laws. You understand? It failed to state where and what location this act was done. It just simply says sworn before me. It does not say who was present, who swore before you. What did they swear to? Wait a minute. They signed on behalf of the corporation. Did they produce evidence showing that they were authorized to do that? No, they didn't. Then this is void. And if the notary is void, the document is attached to is void. Because if it had to be notarized and the notarized is not there, then the document is incomplete. What's incomplete is inadmissible. If it's inadmissible, it may not be used for judgment. And this is the affidavit of service, that's a due process issue. The court can't overstep that. That's jurisdictional. Dismiss. You want a memorandum of law? Matter of fact, CPLR 4511, judicial notice of law. I'm going to give you the opportunity to correct your shit. And when you fail to do it, then I'm going to leave you. Because then that's proof that it was intentional. I showed you the law. I showed you the defect. I showed you the law. Sua sponte, you need to correct this. Failure to do so means that it was an intentional act. Or you're incompetent. Which one you want me moved off the bench for? This is how you deal with them. I'm not asking you nothing. You're a servant. You're a public servant. And you're administrator. That's it. Administrator. That's all you get to do. But the facts, you don't get to alter, dictate, corrupt. You don't get to omit. Omission of a material fact is a fraud. Grounds for dismissal. Period. Knowledge, this knowing law. Yes, just knowing law, man. I don't care what you, I shot your dog, slapped your mother, this, that, and the other. There was 30 witnesses, bop, bop, bop. Look at the complaint. An attorney affirmation. No affidavit from your mother, no evidence of the dead dog, no pictures, no nothing. I ain't got a damn thing to say about none of that. My honor, I moved to dismiss this claim. There's no evidence before the court for which the court can make a judgment. Where is it? I got the claims. This is a complete file. You understand what I'm saying? Why am I talking subject matter? As soon as you start talking subject matter, you give them subject matter jurisdiction. You started talking about it, the door's open. Don't even open the door. Who are you? I'm not here to deliver facts. I'm here to make an investigation. Someone has made a claim on my property. They didn't notify me directly. Who are you? Well, I need to know who you are. You should have did that before you filed this suit. You didn't do no due diligence. I got keys. I live there. Heck of my mail. You don't know that? What you did? File John Doe, Jane Doe? Oh, you traveled under CPLR 1024. Unknown parties. Did you read that statute? Did you know that you had to do due diligence prior to using the John Doe? Where's the affidavit of due diligence showing what efforts were made to identify the proper parties prior to you electing to use John Doe as a space holder? Then, are you aware that you have 120 days from the filing of the complaint to make an amendment to the action to name the proper party? And if you don't do it, the statute of limitations bars that being applied to anybody else. Oh, what case? Katzman versus Doe's 1 through 10. Katzman versus Doe's 1-10, 1 through 10. Look it up. No affidavit of due diligence prior to using John Doe? Well, then you were never authorized. Don't say you did it. There's no affidavit of due diligence in the court. It wasn't served. You ain't gonna file one now. This is really, literally picking their shit apart because they are lazy, spoiled, and conditioned. You think we don't know. They Muppets. They trained in the system. How many times they be in their pocket shaking change, that Jewish shekel shit? Begging help. Begging help, because I banged him. Asked him for a business card, got his business card. It didn't say shit like he said in court. But I can submit that card as documentary evidence. And my uncle told me a fight is a fight is a fight. Ain't no rules to a fight. What you talking about? I'm coming in here. You remember how the Europeans used to fight in lines? Line up from each other. You shoot, da da da. Y'all shoot, da da da. What killed them? What tore that shit up? Guerrilla tactics. That's how you got to deal with these guys. You don't fight them straight up. You don't fight them straight up. You hit them from everywhere they don't expect you to hit them at. And when you hit them, you do acupuncture. You catch them right. You catch them with it. I promise you, they fold like origami. They become pigeons and ducks and swans, all kind of shit. You understand? I went in court 3 weeks ago. I got there, the attorney talking all belligerent. I said, wait a minute, bro. I got your documents. I don't even see a power of attorney in this shit. Fuck you, the law firm that you claim to be working for, there's no power of attorney from the bank here. You know what this cracker told me? This ain't Supreme Court. I ain't gotta have that. The woman from the bank said, can I talk to you? He doesn't represent me. The bank hired him. She wanted to talk because she already know. I already know. Hey, look, heck of the UCC, heck of the mechanics lien, heck of my keys. Look at their leases. All the leases is to me. Understand these is contracts in law. Protected. My standing is, listen, these documents are filed prior to any foreclosure action. Do you have any evidence that you noticed me of any potential foreclosure or sale? I was entitled to, at minimum, to the order of reference. Why? Because I was a lien of record. Look at the order of reference that they petitioned for. Look what the judge said. You must notify all lieners of record, all parties in possession, and anybody else entitled to service. All of these is my tenants. I got publicly posted liens prior to any of this. And I'm turning this shit over. Order to show cause, motion to restore and dismiss and sever. I don't give a damn if you got judgment against all of them. You ain't got none against me. And I want that from the court. Or order of severance. I don't care what you did to them. I got case law here saying that where a party who is an essential party to an action was left out of the action when the plaintiff knew that that party was a necessary party to the full resolution of the case. There has been no mistake, and the plaintiff shall not be permitted to have a second bite at the apple. You can't sue me. Why? Because you failed in law. The UCC is a public filing. One question gonna murder you. Did you do a UCC public search prior to the initiation of this claim? Well, then you didn't do due diligence. Because if you would have sought. But the fact that you didn't does not affect the standing or the right associated with it. So where you didn't, you said you didn't see it, you went through the foreclosure, and you was in violation, you can't even come back and say, well, I want to file against him. Because it was posted in the public. Period. And you were obligated by due diligence to see if there were any liens on the record. And in the order of reference that you agreed to, remember this is an order of the court, you must give notice to any parties in possession, lieners of record, interested parties, or tenants, or anybody else claiming a right who are not named as a party. That's in order of reference. This is what y'all asked for. These are the orders that the judge made. Go right back in them and use them right on you. You violating a court order. What's the result of that? It voids your interest in the property because it was obtained by duplicit actions. You committed fraud upon the court. You told the court you were going to do this, and in fact you did that. Guess who mad at you? The magistrate gonna bust your ass. He gonna bust you because now you did this in his court. Now he got to come back and correct this. So get you. You're not even gonna get me coming at you. When I ask the magistrate for sanctions, when they do sanctions, you don't get the money. The court and the bar get the money. So when you ask for sanctions and they pissed at you, guess what? They're more than glad to bust your ass open because that money ain't coming to me. It's going to the bar association. And it's coming in their name. I done contributed $1 million to the bar association in sanctions this year. They gonna throw me a goddamn party.
Hey, we're coming back to court again.
How you think these judges get reelected to judgeships? Yeah, you're a good judge. You help the state. You keep our coffers full. That's what it is, man. They doing business on us. I left there today, I paid $8 a page for a certification. One sheet. They cost me $1.25 for 5 sheets of paper. 25 cents a sheet, right? But I needed it certified. The certification alone was 1 sheet. It was $8. I got the receipts though. Remember I told you that case, right? I told you. What's the name of the case? Don't forget that goddamn case. Clearfield Trust versus U.S. You take one FRN, you ain't government. One.
Right, I got you.
You're not government. I ain't gonna argue with you. I'm gonna submit the evidence, the receipt with the date on it, and it even got my name on it. Documentary evidence before the court. And I'm gonna submit only one case, Clearfield versus U.S. That's it. I only got one question. I want to subpoena the clerk downstairs. Did you accept a Federal Reserve note as satisfaction for this allegation of debt? We ain't talking no money because there ain't no money involved.
Right.
The statute, the case don't say nothing about money. It says private commercial paper. Private commercial paper is synonymous with Federal Reserve notes because the Federal Reserve is not part of the government. It's an outside entity, so it's private commercial paper. So, give him one FRN, 10 of them, 100, I don't give a damn. Get a receipt, staple that shit to Clearfield, and the man, then you challenge the jurisdiction of the court. That's when you go at it. What jurisdiction are you claiming? Are you claiming to be a private corporate entity, or are you claiming to be government? I dare that bastard to say government. Say it. Then I'm going to hit you with the case law. I'm going to ask you again. The evidence is before the court. United States Supreme Court superior law is before you. What status are you operating in? Is this a private commercial venue, or is this a judicially authorized venue? Which we know it can never be that because of Senate and Congress adjourned, fired itself without day. So we know that, but we're going to pass over some knowledge for a minute. I'm going to give you the opportunity to answer yourself. What are you claiming? This ain't on you, Mr. Punk ass attorney. I'll let you off today. I want you. This is what you do to belligerent judges when they just ignorant and crazy and shit. And then you want to act like that? I have no problem with filing an appeal in your fucking appellate system. Because that's where you get the lower courts is garbage. Read the appellate court. The appellate court, you come there correct, they slay heads. Don't go there playing though. All of the justice goes down on appeal. But you got to understand, why is it like that? Because most people who don't know much or got much money, they can't afford or don't know how to appeal. But the people who know or got some money, oh, they going to the next level. And when they put that law up there, they got to honor it. That's why most of the time, the appellate court decisions, look at this, and you got second department, third department, pay attention to those things. When you cite in a case law, pay attention to what department that case was ruled in. Because Bronx ruled different than Brooklyn counties on different issues. You did? So you might got a good case law, but it's on the third department and your case is in Brooklyn, which is second department. Search a little bit more, find your second department case so they can't deny you. Little shit like that. You bust the head up, you get to the end and they denied you. And in the pen you see, yes, although the case cited by the respondent were persuasive, they weren't persuasive enough to overrule the court's position that such and such and such, and they named 7, 8 determinations in the same department that's consistent with their opinion. See, pay attention to how each department is leaning on appeal, because you know how to attack them. See, like, if you file an appeal, me, I only file an appeal one way. CPLR 5015. And what's that? That's relief from a void judgment. And I usually travel under subsection 4. That's jurisdiction. See me back at jurisdiction again? I'm attacking a void judgment for jurisdictional reasons. So what my document's gonna have? Proof that the judgment was void, and it's also gonna proof that jurisdiction was wanted. No subject matter. I never argue subject matter.
It's even in one jurisdiction.
Right.
No jurisdiction.
Right. Now, what they have a habit of doing, you traveling, if you go, they're trying to put you under, if you just put 5015 and don't put the correct subsection, say you say 1. Well, that subsection 1, if you go under that, the rules under that say, well, you gotta have a reasonable excuse and a valid defense for the claim. I ain't gotta have no excuse traveling under subsection 4, because subsection 4 is specifically a jurisdictional challenge. When I go into CPLR 3211, it's under number 8, jurisdictional challenge. Or standing, number 7. I only argue structure. I do not argue particulars unless I got you all the way fucked up and it's to my benefit to name the particulars, the particular fraud, the particular conspiracy, the particular occurrence of events that led to your actions being deceptive or fraudulent. See, those type of particulars, I'll spell them out, but it's in a vein. I'm describing a particular fraud. I'm describing a particular conspiracy. It's not about subject matter. If I mention facts that are contained within the subject matter, the court can't construe my statement as mentioning or entering subject matter jurisdiction. See, it's knowing those little veins. Oh, well, I paid the rent. Oh my God. Why did you say something like that? Oh, my rent was. My rent was. You understand what that just said? It's a statement about the past. It's a statement of ownership. It's a statement of status. Renter is not an owner. You contract. You said a lot with those 3 words, man. No different than my name is or my address is. Bro, you do not have an address. An address is on a damn building. Are you a building? How do you have an address? Do you not understand that was a trap question?
And the address belongs to the postal.
No, it belongs
to the military.
It belongs to the Department of Taxation and Finance.
Okay.
It's on the tax map. Block number, address.
True.
Department of Finance and Taxation. That's they shit. You do not have a name. Why? Because you are not a thing.
A corporation has a name.
But a corporation ain't the only thing that has a name. And a corporation ain't even actually a thing. It's a figment of the imagination. This is a thing. The name of it is a table. This is a thing. This is a bottle. You are a man. You have an identity. When someone says that shit to you, your first word should be I. Your second word should be am. That right there killed all of that property inanimate shit. You just said that you are a living, sentient being that exists. I am. Why did you say it? Because you did it of your own evocation, of your own volition. You're not inanimate. As an animate, as being animated, you are living.
Full life.
That's the statement and the proof of life. I refer to